Assault is typically the second intentional tort taught in a 1L torts class. This is because, as mentioned in the battery lesson, this tort builds upon the concepts established by battery. In fact, much of what comprises an assault is found in what comprises a battery. The salient distinction between the two is that, unlike a battery, a tortfeasor can be held liable for assault without any actual harmful or offensive contact occurring to the person of the other. All that is required is that the other apprehend the actor's tortious act, and that the actor have the apparent ability to land his harmful or offensive contact. It is the finer points of this distinction that will comprise most of this lesson. Keep in mind that, just like with battery, the acts that can constitute an assault are often subject to criminal statute, but we will be examining these acts in the context of tort law, and therefore only in a civil law context. Welcome to Roman Matter. This lesson will explore the intentional tort of assault. We will cover how the tort is defined, examine its elements, and go over a few examples. A word of caution. This course is intended to answer academic questions only. These materials are intended to reinforce your legal education or to satisfy the curious layperson, not legal advice. And with that, let's get to it. So what is an assault? Which is to say, what does the restatement have to say in regard to an actor who was alleged to have assaulted someone in a civil context? The Restatement Second of Torts, Section 21, describes the circumstances under which a person can be held liable for an assault. It provides that, quote, an actor is subject to liability to another for assault if A. He acts intending to cause a harmful or offensive contact with a person of the other or a third person, or an imminent apprehension of such a contact, and B. The other is thereby put in such imminent apprehension. Section 21, subsection 2 continues, stating that, quote, an action which is not done with the intention stated in subsection 1a does not make the actor liable to the other for an apprehension caused thereby, although the act involves an unreasonable risk of causing it, and, therefore, would be negligent or reckless if the risk threatened bodily harm. Now, to mold this somewhat clinical definition into something more concise and useful, we can say that, quote, to make a prima facie case for assault, the plaintiff must show the defendant acted intentionally to cause the plaintiff an imminent apprehension of immediate harmful or offensive contact to the plaintiff's person. Let's dig into the critical pieces composing or qualifying the definition. This requirement is integral to all intentional torts. Simply put, the tortfeasor must have acted with intent. The Restatement Second of Torts, Section 1, states that, quote, a person acts with the intent to produce a consequence if A. the person acts with the purpose of producing that consequence, or B. the person acts knowing that the consequence is substantially certain to result. We've covered this in our battery video, and if you want a more in-depth look at this aspect of assault, then I suggest you check that video out. But to review, here is the pertinent information. A harmful contact is one that will cause a physical harm to one's person. An offensive contact is one that, quote, offends a reasonable sense of personal dignity, unquote. To be held liable for a tortious assault also requires that the actor have the apparent ability to actually complete the tortious assault. For example, a bank teller behind plexiglass cannot hold an irate customer who slams his fist on the glass liable for assault. Unpleasant though this may be, the plexiglass prevented the customer from being able to harm the bank teller. Such an act, depending on subsequent events, may result in the intentional infliction of emotional distress on the teller. But at this moment, it is not an assault. Again, for liability to attach, the actor must have the apparent ability to complete their tortious act. Imminent means about to happen. Apprehension means perception, comprehension, and refers to whether the plaintiff had any sensory information as to the assault's immediacy. Therefore, the plaintiff's imminent apprehension of the harmful or offensive contact is a temporal condition. The harmful or offensive conduct must be apprehended by the other at the time the actor's act is done or committed. Practically speaking, when trying to determine whether a plaintiff could have apprehended a defendant's alleged act, determine whether the plaintiff perceived the act constituting the alleged assault with his senses. The Restatement Second of Torts, Section 22, writes about this, stating that, quote, an attempt to inflict a harmful or offensive contact or to cause an apprehension of such contact does not make the actor liable for an assault if the other does not become aware of the attempt before it is terminated. That section states the temporal condition regarding this tort. The affected person must perceive the tortious act before the actor terminates his attempt to commit it. Keep in mind that even if an individual is later informed of an attempted assault upon his person, that knowledge is insufficient to constitute an assault. This is because the individual's apprehension of the other's action was not immediate. In other words, the would-be plaintiff must have sensory knowledge of the act or acts constituting the alleged assault before they are terminated. Mere words, without more, are usually insufficient to constitute an assault. The Restatement Second of Torts, Section 31, provides insight on this aspect of the tort. It provides that, quote, words do not make the actor liable for assault unless, together with other acts or circumstances, they put the other in reasonable apprehension of an imminent harmful or offensive contact with his person, unquote. There are some qualifiers to this concept. Comment B provides some context to Section 31. It states, if the actor's words are preceded or accompanied by acts known to the other and understood by him, then those acts may be decisive evidence of the actor's intention to commit the assault and of the other's apprehension of his acts. Conversely, a defendant's act may precede or be accompanied by words which, by themselves, would not rise to the level of an assault, but when combined with the plaintiff's knowledge of the defendant's conduct, may, in fact, rise to a reasonable apprehension of assault by that person. This is context-specific. In essence, if the plaintiff has reason to believe the defendant's words are a prelude to a harmful or offensive contact, and the defendant knows the plaintiff has this belief, then the defendant's words may be sufficient for liability to attach. And with that, let's take a look at some examples. Peter owes Donald $200 he lost over a poker game the two men attended. Donald tried to get Pete to pay up. He's asked politely and even given him more time to get the money to him, but Pete hasn't made good on his debt. And Donald, losing patience with Pete, calls him over the phone and says, "If you don't get me my money, I'm going to break your legs the next morning." While this is certainly unpleasant for Peter, Donald's mere words are insufficient to constitute an assault. Further, the fact that Donald made the threat over the phone takes away any threat of immediacy, even if Donald threatened to break Pete's legs at the time of the conversation and not the next morning. It is apparent that he could not physically do so. However, if Donald threatened to break Pete's legs in person, it is highly likely that he would be liable for assault. This is especially so if, as comment C to Section 31 provides, Pete knew that Donald was a dangerous gangster and had broken the legs of debtors before. In such circumstances, it would be reasonable for Pete to assume that Donald's words were merely preceding an imminent harmful contact to his person. Now, let's take a look at a more straightforward example. Let's assume that instead of a mere verbal threat, Donald and Pete met up in person and Donald brandished a knife when he told Pete to pay up or else. In this instance, Pete likely experienced an assault. He had a reasonable apprehension of an immediate harmful or offensive contact to his person. Donald's physical presence, coupled with the knife in his hand, practically ensures liability. Now, what if Pete wasn't frightened of Donald's threat? Under the common law of torts, that fact would be immaterial to whether Pete was experiencing an assault. Keep in mind, apprehension does not require the plaintiff to be frightened or afraid, only that they witness and reasonably believe that the defendant is capable of engaging in the harmful or offensive touching. Now, the presence of fear can support the plaintiff's argument that they were assaulted, but don't fall into the trap of thinking it's necessary to confirm this tort's presence. Bottom line, an assault is very much like a battery, except being held liable for one doesn't require an actual harmful or offensive contact with the other's person, only that the other, affected person, apprehend the actor's tortious act at the time he engages in it. The actor must also have the apparent ability to complete the assault. Provided those elements are present, an assault has likely occurred. That's it for this lesson. If you found it helpful, give the video a like and subscribe to the channel. Leave some comments below and check back often for more content. As always, thank you for visiting Roman Manor and have a lovely day.